The tension between Drake and Universal Music Group has escalated into one of the most high-profile music industry legal battles in years, and it's getting more personal by the day. What began as a lawsuit over a single track has now spiraled into a bitter fight about corporate accountability, executive involvement, and the boundaries of creative expression. At the center of it all is one question: how far can a record label go in promoting a hit before it crosses the line into defamation? Welcome to Celebrity Rap Life, where the red carpets never roll up and the spotlight never fades. The rewards are legendary. Because in celebrity rap life, every downfall can become a comeback, and every headline tells a deeper story. Hit that like button, subscribe, and turn on notifications so you don't miss a second of what's coming next. This case isn't about a minor lyric or a fleeting insult. It revolves around Kendrick Lamar's chart-topping diss track, Not Like Us, which didn't just make waves in the rap world. It became a cultural moment. Released by Interscope, a label under the Universal Music Group umbrella, the song contained a bar that hit harder than most. Say, Drake, I hear you like M. Young. Certified lover boy. Certified pedophiles. For Drake, this wasn't just rap bravado or an artistic jab. It was, in his words, an unmistakable, false, and damaging accusation that struck directly at his personal and professional reputation. The stakes were raised further when Not Like Us exploded in popularity, climbing to #1 in both the US and UK. It wasn't just another diss track on a playlist. It became the centerpiece of Kendrick's 2025 Super Bowl halftime show, broadcast to one of the largest television audiences on the planet. The performance featured the song's controversial artwork, which displayed Drake's home alongside map-style icons typically used to mark the addresses of registered sex offenders. From Drake's perspective, this was not merely hip-hop beef. It was a calculated smear campaign. His lawsuit, filed in January, accused Universal Music Group of approving and launching a campaign to turn the track into a viral sensation, with the specific, unmistakable, and false factual allegation that he was a criminal pedophile. His legal team claims the label's actions encouraged the public to see him as a legitimate threat, even going as far as suggesting that vigilante justice could be justified against him. It's important to note that Drake has not taken legal action against Kendrick Lamar himself. Instead, he is going directly after the parent company, the deep-pocketed corporate entity that, in his view, allowed and amplified the attack. Universal Music Group, for its part, has dismissed the lawsuit as utterly without merit, painting Drake as a sore loser in a rap battle he initiated and willingly participated in. In March, UMG argued that diss tracks have always been part of hip-hop's DNA, celebrated precisely because they push boundaries and deliver outrageous insults. To UMG, Drake's attempt to litigate an artistic feud threatens the entire art form. But the latest developments show that Drake's team isn't backing down. In fact, they're pushing harder. This week, his lawyers filed 2 new motions that could drag some of the highest-ranking executives in the music business into the legal spotlight. The first motion zeroes in on Sir Lucian Grange, UMG's British chair and chief executive, a towering figure in the global music industry. Drake's lawyers allege that Grange had a role in and knowledge of the scheme to defame and harass their client, and they are demanding access to Grange's texts, emails, and other communications. They argue that these documents could reveal whether Grange was personally involved in decisions surrounding the marketing and promotion of Not Like Us when it dropped. Up until now, UMG has firmly refused to hand over Grange communications, stating that the CEO had no meaningful involvement in the matters and decisions at issue in this litigation. In a letter sent to Drake's lawyers back in July, UMG's legal team emphasized that Grange, as the head of a massive multinational corporation, does not personally oversee individual record releases, even high-profile ones. They claimed that any relevant information in Grange's files would likely be cumulative and duplicative of what could already be found in communications from other UMG staff. Drake's lawyers, however, see a crack in UMG's position. They point out that the company's language has shifted from saying Grange had no role at all to saying he had no meaningful involvement. That subtle change is exactly why they believe the court should compel UMG to collect, review, and produce documents from the CEO's files. In their view, Grange isn't just a distant executive, but potentially a decision-maker whose actions could help prove actual malice, a crucial legal threshold in defamation cases. The second motion filed by Drake's team takes the case in another direction, focusing on what they describe as UMG's history of censoring content. They argue that the company has previously exercised the right to pull or alter material when it contains defamatory statements, and that it could have done the same with Not Like Us. To them, the fact that UMG chose not to intervene here is telling. But this motion also introduces another contentious claim, that UMG intentionally fueled competition between its two powerhouse labels, Republic Records, which releases Drake's music, and Interscope, which releases Kendrick Lamar's. The suggestion is that executives at UMG had a financial incentive to let the feud play out publicly, even if it meant one of their top artists would be defamed. Drake's lawyers allege that the structure of bonuses, market share battles, and internal prestige made Lamar's victory, and Drake's humiliation, good business for certain parts of the company. To dig into this angle, they're requesting a broad range of documents, financial records, internal communications about the rivalry between Republic and Interscope, and even Kendrick Lamar's unredacted record contract. They believe this evidence could show that UMG executives didn't just tolerate "not like us," they actively encouraged it for competitive gain. UMG has so far declined to comment on the new motions, sticking to its earlier stance that Drake's claims don't hold up legally. They maintain that diss tracks are an essential and protected part of music culture, and that if courts start treating them as grounds for lawsuits, the creative freedom of artists everywhere will be at risk. Meanwhile, the legal battle has become a lightning rod for debate both inside and outside the music industry. Fans, artists, and critics are divided. Some argue that Drake is setting a dangerous precedent by dragging a record label into court over a diss track, especially given his own history of lyrical jabs at other artists. Others counter that "Not Like Us" went far beyond the norms of artistic beef, accusing him of a crime so serious that it could never be brushed off as just wordplay. The inclusion of the lyric in the Super Bowl halftime show, one of the most visible and influential stages in the world, only intensified the controversy. For Drake's camp, this wasn't just a song lyric, it was a message endorsed and broadcast by one of the largest entertainment companies on earth, to hundreds of millions of people, in a context that made it feel credible. Behind the scenes, the case is also raising questions about the role of major label executives in creative disputes. While Grange and other top figures may not be in the studio with artists, their influence over marketing, promotion, and public image can shape how a song is received and how far its message travels. If Drake's lawyers succeed in getting access to those internal communications, they could reveal how much, or how little, executive-level strategy played into the rollout of "Not Like Us." But even if Drake wins access to these documents, proving defamation in a case like this is notoriously difficult. As UMG's lawyers have already argued, diss tracks thrive on exaggerated, outrageous claims, and the law often treats them as rhetorical hyperbole rather than statements of fact. To win, Drake will have to show that the lyric was understood as a literal accusation, that it was false, and that UMG acted with actual malice in promoting it. For now, the courtroom drama is set to continue, with each new motion adding layers to an already complex dispute. What began as a war of words between two of hip-hop's biggest names has transformed into a test case that could reshape the boundaries between artistic freedom, corporate responsibility, and personal reputation in the music industry. Whether the case ends in a courtroom victory, a quiet settlement, or simply fizzles out, it's already making history. In an industry where public image is currency and controversy can sell records, Drake's willingness to take on his own corporate partner and drag its top executive into the fight marks a rare and risky move. And while the beat may have started on wax, the next verses will be written in legal briefs, depositions, and courtroom testimony. One way or another, the outcome will echo far beyond this feud, setting a precedent that could affect how the music business handles its most controversial hits in the years to come. This story is far from over, and the truth is still unfolding. I want to hear what you think. Drop your take in the comments. And if you don't want to miss the next twist, hit that like button, subscribe, and turn on notifications so you don't miss a second of what's coming next.